Thank you. All right. I have two more cases on my calendar. Courtroom 2, who do we have next?
We have position number 12, Mr. Sparks.
Oh, three more cases. Okay. This is Mr. Louis Sparks, accused of a violation of the law regarding squatters, 16-7-21.1. Case number is 25 CR 0000147E. Offense date appears to be December 20th, 2024. Now, Miss Franklin Brennan, did you get that phone number that was sent to everyone? Okay, thank you. Okay. Mr. Sparks, you have a right to remain silent. Anything that you say in open court, your statements can and will be used against you. You have a right to an attorney, and representing you presently is going to be Mr. Michael McLean. Any priors?
Well, no squatting or history. 2024. He got an open case, ag assault, crude to the third, criminal damage to property, second degree, obstruction, simple assault. It's 24 PI 002815. Open theft by conversion, 22 SC 182232, 2018 FTA.
Miss Allen?
Thank you, Your Honor. This is an incident from December the 20th. There was actually a hearing in magistrate court in front of
Judge Ashley.
Judge Ashley on the 7th. He found probable cause for a count of squatting. The owner of the location at 5558 Union Point Place in Union City had to do a private action for a warrant because the defendant refused to leave the premises. He's filed in a bunch of sovereign citizen, UCC, gobbledygook, and has an AKA. The victim in this case is Mr. Douglas Walls, the owner. Judge Ashley issued a $10,000 good bond after hearing on this matter. I would note that the open 24 PI case mentioned by pretrial is from April of 2024. The defendant in front of you was released on bond following his arrest in that case. And as part of that bond, he's been ordered to stay away from the location. That's the location where his wife and his 5 children live. And the case in Superior Court is an aggravated assault against her in front of those children.
We've got squatters invoking imaginary paperwork, defendants filing what can only be described as legal mad libs, and one individual who seems to think calling themselves a king somehow overrides Georgia state law. Spoiler alert, it doesn't. These cases all come out of Georgia, but the arguments you're about to hear could have been ripped straight from the sovereign citizen playbook we've seen fail over and over again in courts across the country. Fake UCC filings, special appearances, magical thinking about jurisdiction, it's all here. And the common thread? Every single one of these defendants confidently believes the rules don't apply to them, right up until a judge reminds them that reality does not bend to nonsense. So as we go through these hearings, pay attention to how patience slowly wears thin, how legal consequences pile up, and how confidence without competence turns into self-sabotage in real time. Let's get into case number 1.
So not only is he fighting to stay at the property, even though he has no legal right to possess or be on the property, and the owner of that property had to go through the court system to get him out, the court has already ordered him to stay away from that location because of the open felony aggravated assault. We're asking to keep that $10,000 good bond that Judge Ashley put in place. I'm guessing it was for a reason. It might be part of the 60 pages of things that have been filed into this case and the gobbledygook and someone who just frankly refuses to acknowledge that they've been ordered to stay away. We will continue to try to be in contact with the victim in that 24 PI case, Your Honor, Mrs. Duncan, and I've already alerted the DA's office that this gentleman is now back in jail for a violation of the bond in that case. And so that's where we are. We'd ask for no contact with the gentleman who owns the location, Douglas Walls, or anyone else who's living there, to stay away from 5558 Union Point Place in Union City. No drugs, alcohol, or weapons. Thank you.
Mr. McLean?
Your Honor, my client, Mr. Sparks, is a high school graduate.
He has been working in the ministry for a year and a moving company for 8 years prior to that. Based on the charges, he's also been in Georgia quite some time, over 11 years. He's 42. Your Honor, based on the charges, we understand what the state has been concerned about and is concerned about. We would ask the court to consider a signature bond, and if not a signature bond, then something like a $1,000 or $2,000 surety.
It's going to be a $5,000 surety bond. I'm not sure whether he's got a bond surrender in his 24 PI case 002815. I just see some notes about that, but y'all can look into it.
I didn't see that he had a bond surrender. It's just real clear he can't go back to that location as a condition of his bond. It's a $20,000 good bond, I believe.
Okay. But meanwhile, it is a $5,000 surety bond for this particular case to stay 500 yards away from 5558 Union Point Place in Union City, 30291, to have no further contact with Douglas Walls, no illegal drugs, no alcohol, and no weapons and no firearms. And his next court date will be January.
Right here is where the mask slips. When the prosecutor says, sovereign citizen UCC gobbledygook, on the official court record, that tells you everything you need to know about how often courts see this nonsense. Judges and prosecutors don't use that language lightly. It's shorthand for filings that look long, complicated, and impressive to the person submitting them, but mean absolutely nothing legally. And notice the irony. Sovereign citizens constantly argue there's no victim. Yet here we have a named property owner who had to go through a private warrant process just to remove someone who refused to leave. That's not theoretical harm, that's real-world impact. Even worse, this isn't happening in isolation. The defendant is already under court orders tied to a separate felony case, and instead of complying, he doubles down. This is a pattern courts watch closely, because it shows whether someone respects court authority or sees it as optional.
Go ahead and go forward on position number 1. All right, so Miss Ellis, you could come into the camera for me.
I'm here by special appearance, Judge.
Okay, hold on 1 second. So Miss Ellis, if you, I just need to swear you in first, and then you can make your statement. If you could please raise your right hand. Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth under penalty of perjury?
I stand in honor and affirm that my words shall be truthful with full reservation of my rights under God's laws and natural law.
Okay, you can put your hand down now. Thank you. All right. So I have already reviewed the case. I remember Miss Ellis from previous dispossessory where there was, long story short, that the parties, at least at that time, did agree that she had taken subject to a valid lease. And that they had not asked, they had not pled for non-payment, and I'm assuming this is where this new dispossessory is based on the non-payment, based on the lease that she had with the previous owner. Is that correct, Mr. Thor?
That is correct, Your Honor.
Okay, and it looks like so, Ms. Ellis, I looked that you did file a late answer in this case. I saw that you had said you had emailed your answer or some sort of response to the plaintiff. That does not count as an official answer. So it actually, your answer does have to be uploaded into the file within the 7-day time frame. So it is a late answer. I did also just reviewed. I didn't see any legal defenses or counterclaims in this. So this would technically today be a judgment on the pleadings. So Mr. Thorpe, if you'd like to present your case.
Yes, Your Honor. So this was filed for non-payment of rent. Service was effected on December 10th. No answer was filed. Defendant is in default. We request a immediate writ of possession.
Okay, with the judgment on the pleadings, it would be 7 days from today. So that would be the 5th of February. Since you, well, technically,
that'll yeah.
It was a late answer. You are right.
May I, Judge?
Yeah, just 1 second. I'm just getting his case first, and then I'll come to you. Let's see. Yeah. Okay. So based on the answer being filed late, so you're just seeking the writ. You don't want the answer accepted, so you're just seeking the writ.
Correct, Your Honor.
Okay. Okay. So, Ms. Ellis, before you make your statement, I just want to make just a general statement about the fact about the answer being late. Okay. So here are the pros and cons. You filed a late answer. Like I said, there wasn't any legal defenses or counterclaims in the answer that you did file, but you did file a late answer. If you want me to accept that answer, that would subject you to being subject to a money judgment in the case. However, it would give you an additional 7 days before the plaintiff could file for a writ of possession. If your late answer, if you choose to have me not accept your late answer, then the writ would be available for them to apply for as early as today, but you would not be subject to any form of money judgment that they could use to collect on. But you would have to, the writ would be available to them a little bit 7 days earlier than it normally would have been.
And here's where things go from bad to worse. The court casually drops a detail that completely destroys the defendant's narrative. There is a living victim, and it's his wife, tied to an aggravated assault case involving children as witnesses. That matters a lot. Courts take bond violations extremely seriously, especially when they involve domestic violence allegations. The judge isn't just deciding bond based on this squatting charge. They're looking at the defendant's overall behavior, prior orders, and willingness to follow conditions. When someone is already ordered to stay away from a location and still ends up back there, judges read that as defiance, not confusion. And defiance is how bonds get denied, revoked, or upgraded. Sovereign rhetoric doesn't erase court orders. It just convinces judges you're going to ignore the next one too.
So I guess my first question, so I guess if you'd like to make your statement, but then I'm going to need to know whether or not you want me to accept your late answer, because if you want me to accept your late answer, there would probably be a money judgment associated with your order, but the writ would be applied for in 7 days. If you do not want me to accept your late answer, it would just be a writ available today or whenever they filed for it already, I believe. The writ would be signed today, but there would not be a money judgment against you. Okay. All right. So if you'd like to make your statement now.
So under what authority is the abatement that I filed could not be the answer? Because is it ethical for the court not to accept the abatement that I filed, because that's how I usually filed, and it was always never a problem?
Filed. There's nothing filed.
So I have that evidence because I went into the court and they showed me that was filed, and they said to me, that's what you were stating this court case on. So I want that answer to be put in place as the answer for that abatement.
If you file the late answer, like I said, it would subject you to a money judgment. I'm not sure what you mean in terms of an abatement, but the rules for dispossessories are pretty simple. If you are not paid your rent, they will file based on non-payment of rent. They'll issue a demand. And then if you do, and essentially, unless you can show that you've got some sort of legal defense,
I do.
Itself, and what would that be?
I do have legal defense. First, I want to repent for all my debts, and I like to rescind my prior actions to start over. I have evidence that I filed a case. I filed to buy the premises from the real party of interest. That's why I was asking this attorney if he does have evidence of who's the real party of interest on this property. Because even yesterday, I was speaking with the owner of the property, telling me that I need to send in a GAR and my proof of funds. So this is not about possession or monetary value, because I have all that evidence.
So Ms. Ellis, in the previous case, it was shown that this plaintiff purchased the property at foreclosure. You had a lease with the former owner, and like I said, there is nothing along those lines. Hold on one second.
I do have that evidence, Judge, because we never get to that situation because of all the situations that were happening. I do have all that evidence.
Do you want me to accept this, ma'am? Do you want me to accept your answer or no?
Yeah, I want you to accept my answer so I can move forward.
This is a perfect example of how defense arguments can sound reasonable on paper but collapse under context. Education level, work history, and time in the state do matter. But they don't outweigh an open felony case, prior bond conditions, and documented refusals to comply with court orders. Judges aren't just weighing who you are, they're weighing risk. Risk to the alleged victim, risk to the public, and risk that you'll ignore the court again. That's why the judge lands on a surety bond with strict conditions instead of a signature bond. It's not punishment, it's containment. And notice how the court carefully spells out distance requirements, no contact orders, and weapons prohibitions. This judge is building a paper trail for what happens next if those conditions are violated again.
All right, I will accept your late answer. That does mean, Mr. Thorne, that the writ would be available in 7 days, but you can seek a money judgment. Ms. Ellis, you can make whatever argument. I've read through everything you filed in the case. It does not present any sort of legal defense to this dispossessory proceeding. All right, so Mr. Thorne, she does want her answer accepted. So if you'd like to present evidence on the rent owed, you can do that if you'd like.
I believe you have a copy of the lease agreement, Your Honor. Monthly rent is $23.50 with a $30 late fee. Rent has not been paid since October. It was found, I guess, in the prior case handled by the prior counsel that rent had been paid through September. So October, November, December, and January, and late fees would be $9,520.
Okay, you said it was $2,350 per month?
Correct.
And then that would be...
And a $30 late fee.
So you're not seeking... Okay, so you're just seeking through January?
Yes, Your Honor.
Okay. Let me just check.
And may I ask a question, Judge, if that's okay?
Just 1 second. Just 1 second.
Okay,
Yeah.
thank you.
1, 2, 3, 4. 4.
Do I have that wrong?
Okay. So I did. So that's 4 months, October, November, December, and January at $23.50 per month, plus $120 and $30 late fees per month. That amount is $9,520. All right, Ms. Ellis, what would you like to say?
So I just need to ask the question. So if the payment is not received while I'm negotiating with the owner to buy the property, you said in 7 days, what's the next step?
Well, they're not required to accept any pay. If they choose to accept payment from you, that would cancel the writ in this case. So if you come to them and you guys are able to work something out and they agree to accept funds from you, that would cancel the writ of possession in this case. But again, that's something you'd have to reach out to Mr. Thorne to talk about. But again, like I said, if they did accept, the triggering thing is them accept, you can, if they accept it, if they accept the funds, if you send in funds and they accept it, that would mean they would have to cancel the writ. But otherwise, the writ would be in place.
So what is being done today? You're filing a writ for possession in 7 days? Is that what you're doing?
Okay, the landlord will be able to, because I'm accepting your late answer per your request, the landlord is seeking a money judgment in the amount of $9,520, and then they will be able to apply for writ of possession by 11:59 p.m. on next Wednesday, which is the 5th of February.
So that will be a new case or the same case?
This is this case, ma'am. This is the order in this case.
So will I be back in court or not?
This case is going to be over as of today. This will be a final order in the case. I will enter that order, and then the writ will be available to them to apply for at 11:59 p.m. on the 5th of February.
So is this a default judgment that is going to be closing out today, you're saying?
This is not a default judgment. It's a judgment on the pleadings. You didn't present any legal defenses. I'm accepting your answer, but there are no legal defenses or counterclaims regarding this dispossessory. So they're going forward today just on the pleadings. Based on the pleadings, the amount owed is $9,520. And like I said, one more time, the writ will be available at 11:59 p.m. next Wednesday, which is February 5th.
Thank you.
All right, so that'll be the order of the court. Mr. Thorne, I will prepare that order. Okay?
Thank you, Your Honor. I appreciate it.
Thank you. Have a good day, sir. You're both free to go.
The transition here is important because while the first case showed sovereign thinking colliding with criminal law, this next one shows it crashing headfirst into civil procedure. And civil courts are even less forgiving. Dispossessory courts run on strict timelines. Miss them and you lose by default. There's no dramatic trial, no emotional appeal, no sovereign loophole. just deadlines. And when someone starts a hearing by announcing a special appearance, experienced judges already know what's coming. Confusion about basic filing rules, invented defenses, and arguments that sound philosophical instead of legal. This judge, to her credit, stays patient, but patience doesn't rewrite statutes. Civil court is where legal fantasies go to die quietly and expensively.
Is at the medical unit. He is accused of criminal trespass under case 24 CR 8301G. Mr. Harris, you have a right to remain silent. Anything you say in open court, your statements can and will be used against you in the treatment of your case. You have a right to an attorney, and representing you is going to be either Mr. Bartel or Ms. Kim or Mr. Haddad. Okay.
No, Judge. So he's proceeding pro se.
Pro se? Okay. Thank you. Mr. Harris, you have a right to an attorney. If you choose to waive your right to counsel, then you will be depriving yourself of legal experience and expertise. If you decide to represent yourself, you are responsible for understanding the criminal laws and procedures and how they affect your personal freedom and your any other matters such as open cases, your job, your residency, or any other licenses you may have. And also what kind of impact it will have on your criminal conviction record if you have one. But it's really up to you whether you would like to have appointed counsel at no expense to you or whether you'd like to represent yourself. So, Mr. Harris, how would you like to proceed in terms of having an attorney?
No, I'm okay. I'm gonna represent myself. I'm a monarch or a royal sovereign. I have divine rights of a king and also sovereign rights. I have non-monetary conditions in the state of PA, personal and secure bond in Maryland, and I got surety bond here in GA. I have eminent domain, so any private property that was established like in this land is for public use for myself.